They try to silence the truth we shout, but we're still here, we're still calling out. Corruption hides behind a badge and name. We light the fire, expose the shame. We're justice seekers, we'll fight the fight for every voice lost in the night. My life mattered is the cry we sing for the ones they tried to bury within. It's just us, we're a movement wide. Together we rise, won't run nor hide. The stories echo, the pain runs deep. For stolen lives we can't just weep. Elected power but their hearts are cold. We'll bring the truth, let it be told. We're justice seekers, we'll fight the fight for every voice lost in the night. My life mattered is the cry we sing for the ones they tried to bury within. It's just us, we're a movement wide. Together we rise, won't run nor hide. We're justice seekers, we'll fight the fight. The heroes undo the harm, calling out corruption. We'll stand tall for justice and truth. We'll risk it all. My life mattered is the cry we sing. Together we rise, let freedom ring.
Hi, good morning, social change warriors, justice seekers. Catherine Felton Page here this morning. Just finished my coffee, had a late night, couldn't sleep, so I'm moving slow. Thought it would be interesting today to follow along with anyone who wants to join me today, and let's see what kind of fuckery disclaimer is going to come up as we go this morning. Things have sure been wild, haven't they, in the Karen Read and Justice for John O'Keefe world the last 2 weeks. It's supposed to be the calm before the storm, the break in between trials. If haven't followed, first trial was a hung jury, lots of drama. we'll chat about that a little bit here as we listen this morning. Good morning to Kara Veach, and good morning to Julie. And hello, hello, Kathy. Thank you for joining me today. I appreciate it. I've never done this before, this living alive. I've always watched the court case and then followed along with whoever was streaming it, maybe some of the other content creators who, we all follow from time to time who are big in this case. So I don't particularly think I want to compete with them. I'm not trying to compete with them. But today I have things to say. And so I know I'm not going to say it on their streams, or those chat boxes drive me nuts when they've got 600, 700, 800 people in them, which kudos to them, right? That's fantastic. But I get a headache trying to keep up with that. So I have my own live stream channel now. So why not, right? Why not hop on and chat about it with those that care to join me. And for those of you in replay that follow us on Friday Night Lives, I hope you'll, check out the replay later and hear what we have to say. So just as a reminder, I'm going to remind all of you who've never been here before that I am definitely in the camp that Karen Reed did not run over John O'Keefe with her car. My former police officer training in the police academy, in the in-services, and in the years I was a patrol officer, I was the first one on the scene for many motor vehicle pedestrian crashes because I worked at a university. So as you can imagine, there were bicycle, car, pedestrian, you name it. So I would either be the first or the second because I was patrolling the campus in my squad car. So, and the Madison city streets in Madison, Wisconsin, all go all around. Most college campuses are set up that way. Very few are completely separate from city streets. USC is where I did my master's degree because that's all gated in. So you're not going to have any kind of high-speed chases or any kind of major traffic stops at a campus like USC. But there's plenty of campuses around the country that just kind of wove into the fabric, right? They're woven into the fabric of the town that they reside in. So in Madison, Wisconsin, the UW is woven into the fabric of downtown Madison, where there is a beautiful capital of Wisconsin on one end of this street called State Street, and the campus is on the other end. So on many occurrences, I might have gone as a backup to a Madison patrol officer who was dealing with something on State Street, which was considered the city of Madison. But the campus then was right there, all around it, woven into the fabric of the city. So I know for a fact that everything that happened that day, from the second that they found John in the snow, Carrie and Jen and Karen, was completely messed up and not at all what should have been done. There was zero police protocol from the very second that the first officer arrived, and continued for days and days. And they expect us to believe that that was all normal police behavior. And I say bull, okay? And so many of my fellow officers say bull too. And Sean on the golf, obviously he was an agent. I don't know if Sean was ever a patrol officer. I don't know that I ever asked him that, but he still says bull all of his years of being in law enforcement. And so does my dear friend, from Indiana, Ed Byers. He thinks it's absolutely nonsense the way they handled the scene that morning and the continuation of interviews that day and on days on. And the whole thing is absolute crap. That's all I'm saying for now, but I'll say more later. So I'm going to bring Kara up to the stage. She's going to chat with us while we watch what's going on. So just as a reminder to all of you that have never been here before or just joining me, I am complete support of everyone that lives in Canton and Stoughton and all the surrounding areas for all the absolute disgusting behavior that has gone on with the Canton Police, the Stoughton Police, and the Massachusetts State Police, for all of these beautiful humans who have had their lives forever affected. As we know, Sandra Birchmore passed away. Her death was ruled an unaliving, but we know by herself, but we now know that didn't happen. And many of us knew that wasn't the case for years and years. John O'Keefe was, they say, was run over by Karen, but we know that didn't happen either. We believe there was a fight that happened in 34 Fairview that night over something that was going on between John and the Albert brothers, I believe, Kevin, Chris, and all of them. So, and then of course, poor Enrique with that ridiculous, there is no way in heck that kind of training ever happens in legitimate police agencies. Police are not trained at that level where an officer could literally lose his life. when officers lose their lives in the police academy or in service, it's always an egregious accident. Sometimes the fault of the person, sometimes the fault of the trainer, but never what they put him through. That was egregious. His family deserves justice. So we, social change warriors, we have been standing for all 4 of these beautiful humans from Massachusetts, and we will continue to do that until they get justice. So, as I always say, we are stronger together. And that's why Social Change Warriors was formed 5 years ago, because it is not business as usual anymore. Communities have to start standing together. You have to speak out. I know it's scary and it can be daunting, but we have to, because there's too much tomfoolery going on. There's too much crime, too much corruption. We can't just go about our daily lives and think someone else will put their neck on the line. Someone else will handle it. We can't do that anymore. So I'm asking all of you, we have to be a community. Stronger together is what has to happen in order for us to go on. So let's get going here, because I know that we're getting close to the start of court. So let me bring up Kara to the platform with me. And again, welcome, Julie. Welcome, Kathy. Nice to see you. And hi, Kara. How are you today?
Oh, I'm doing good. I've been listening to my podcast all morning.
Kara's trying to catch up, because I brought her into this when Kara and I first met because of the death of her dear husband, Jason, whose case we are covering every week for you, mostly on Wednesdays, sometimes on Thursdays. So we'll have another big update tomorrow night for you with more audio from the interviews that the Volusia County Sheriff's absolutely butchered, according to us so far. So be sure to tune in tomorrow night if you can at 8 o'clock, Social Change Warriors, for more on justice for Jason Veach. And we honor Kara and all the work she's done on her husband's behalf to get justice for him.
Thank you. Yes, I've been listening to Proctor's lies. I meant testimony this morning, and it's mind-boggling. It's crazy. This whole case is crazy.
I'm pulling up the feed, so tell us how far you are.
So I feel like it's kind of jumped around a little bit. I've heard Brian Albert's testimony now. I've heard Jen McCabe's. They are right now interviewing a doctor, an analyst that she looked at the debris is how it went in, but it was brought in by Proctor way afterwards. So, it didn't come in with the rest of the evidence.
Right.
Something Proctor.
Right. Yep. I know exactly where you are. All right. I'm trying to bring up the feed. I'm just going to Boston 10 first of all. Julie, if you're on a different feed that you think is better, let me know. I'm on a commercial right now, so give me a second to see if I've got it pulled up here. If you're on a feed you'd rather me show, just let me know, Julie. But I'm going to go with Boston 10 for right now. It says the defense for Karen Ring is continuing its push for 2 charges to be dismissed after attorneys say jurors came forward with new information. Yeah, that was from before, but I think they're live. So let me trying to find the one for today.
Yeah, it's kind of crazy that they didn't drop those after she was found not guilty.
Right. Oh, I see. I'm on the stream from the old court case. Let me see here. Here we go. Let me go to their live platform. I decided to do this, guys, at the last minute, so I didn't have it pulled up because I was not planning to do this today, but I thought, why not? So, okay, here we are. I think this is it. I think. Yeah, it says 11. Okay, yeah, nobody. Okay, yeah, it looks like they're all just coming in. So let me go back to our stream. Let me share it. I think this is the right feed. There we go. Let's see, which one is it? I think it's this one. If it's not this one, I'll have to come back. There it is. Okay. And I don't think.
Quote, grave concerns. Good
Can you
morning,
hear
everyone.
that,
Thanks
Kara?
for being with us.
Yes.
So part 2 of that court hearing comes as we learn more about the federal investigation into the handling of that case. NBC 10's Minash Kongwari is outside the courthouse with the latest.
A lot of new developments as this case prepares to go to its second trial. The defense is trying to prohibit a meteorologist from ever taking the stand in that trial. But perhaps the biggest storyline, Karen Reid's defense team on the hot seat in a hearing today. Now, as you know, Karen Reed is being accused of killing her boyfriend, John O'Keefe, back in 2022 after backing her SUV into him after the pair spent a night out drinking with friends. Her defense believes she is being framed. And in the first trial, put up experts from ARCA Incorporated. It's an engineering consulting firm whose experts testified that damage to Reed's taillight was inconsistent with striking a human and that O'Keefe's fatal head injuries were inconsistent with getting struck by a car. Well,
It's frozen.
now
Or buffering.
The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA witnesses were expecting to get paid. So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts.
Defend themselves, maybe.
And that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not 1, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So That was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel
Okay.
to all of your concerns. I have a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with Your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
And should I hand it to someone here to have it handed to you? Bring it
A
up.
court officer
job.
will take it
Love
from
the
you.
idea of a notebook.
I appreciate that, Mr. Lessie.
You're welcome.
Thank you.
There's another notebook to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Okay. You know what? Actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor.
All right, Your Honor. Very smart of you. Great. All right, she's going to take 5
Not
minutes.
complete.
What do you think, Kara? Like the notebook idea?
Absolutely.
Yeah.
To hide, whereas the common one has tons. Absolutely.
Yeah, the notebook's brilliant. I love it. It's great. All right, let's go see what's happening on Twitter. We got 5 minutes.
To have pause for now, we will bring you back down to Dedham when they resume. And later tonight, be sure to tune into our sister station,
now.
NBC 10 Boston, for a special edition of Canton Confidential. We'll examine everything that's happened today. New protections are being added to the Prudential tunnel ceiling. This comes after concrete, you see here in this video, fell on Friday, damaging several cars driving below. Alicia Palumbo is outside the tunnel where construction is coming to a close. All voted last night to fire Town Administrator James Ryan. When he was appointed in January, Ryan toured the police station and asked the town's longtime police.
There we go. I got it to pause there for a second. So this notebook was a great idea. That's what Bev likes, this kind of stuff. So that way she can kind of look through it, and then he has something he can, refer to prove to them that they did everything they were supposed to do. Julie says, well, this sounds pretty good so far. Yeah, I mean, so far so good. She wasn't even going to make them respond, but I think it's very smart that they are responding. Don't you, Kara?
Yeah, absolutely.
Because why push it out? I mean, why wait to see what she's going to say and then have to defend yourself? Just do it. If you know you did nothing wrong, then great. The notebook has everything, and that'll be that. I think this is, well, I saw a post on Facebook this morning from Sean on the Gulf, and he just said that he said a lot, but he said this will basically turn into be that whole thing is a nothing burger, as he puts it, because it was all just happened on the fly when Hank, basically said, I got the emails from the feds when he didn't. And then he backed it out because Bev was suspending the hearing. He's like, oh boy, I better remember. I don't know. I don't get it. Like, there's no way someone with his intelligence and education and the position he holds accidentally said the feds. I think he was trying to get away with it. I really do.
Yeah. I mean, they're cons, all of them. I don't know how they've done. I don't know how they've gotten it this crazy.
Oh yeah, it's unbelievable. But I'll tell you, crime and corruption is happening everywhere in our country. And when those in power have the backing from people way above them, all kinds of things can go down, and it can take years. I mean, it took Ed Byers in Indiana, Clark County, years to root out the corruption, and they're still rooting out. They've only got a few people in jail because it takes forever sometimes to get enough evidence. You in this, like this instance with Karen is prime. If you don't have the proper evidence that you don't believe that a jury can beyond a shadow of a doubt, and in Massachusetts, that extra caveat of above moral certainty. And if you as the prosecutor and the DA, you don't think you've got enough for that to happen, you can't go forward and you can't charge anybody. So Karen should have never been charged in the first place. And especially after the grand jury, when everything came out, they should have never taken it forward. It's a complete travesty. And there's other cases that we need people to be charged, and they're not charging them either because they don't feel they have enough to get it past a jury. They have to believe with as much probability as they can that a jury will find that person guilty.
Correct. Yeah.
So that's why Suzanne Morphew doesn't have any justice right now, because they don't have enough evidence to. Are we back? Let me see. Add to the stage. No, not yet. They don't have enough evidence to rearrest. They can rearrest her husband because they arrested him and then they unarrested him, and they left the door open so that if more evidence came to light at the time when they unarrested him, they hadn't found her yet. And I'm pretty sure he planned on that. Where he put her, honest to God, if there hadn't been the coincidence of another missing woman in that area, they would have never found her. They would have never looked there. She would have remained buried there, in my opinion, forever. So that was a coincidence that Suzanne Morphew's body was even found. And then they were able to confirm that she had been shot with a tranquilizer gun. And unfortunately, there's still no arrest of him in her case, and there's really nothing. I look every day to see if there's any new filings, or I'll have to start going to the actual court there and going on that page and trying to see what I can see, because there's just, the media is just not covering it here. It's not being covered nationwide at all. It may be being covered in Colorado here and there, but it's tough. Hey, Willie B, glad to have you. Glad to see you covering this live. Thank you. Justice for John O'Keefe so he can rest in peace comfortably and restore faith in other victims, including the kids, Karen Reed. Yes, absolutely. It's I just thought, you know what, with the trial coming up, I am retired. Why not? Why not cover it live? We have enough of us together. There's like a good 20 to 30 of us that come every week live on Friday Night Lives, where we'll be able to go over all the testimony. So I'm going to just cover it live for all of you who want to chat and have a peaceful place to chat. We don't bully in our conversation box, I like to call it. We don't bully each other there. We give each other the right to have an opinion. We might not always agree exactly 100%, right? We probably don't agree. I've already had a debate with James Jackson when he was on our show 2-3 weeks ago. A lot of people think Higgins is the big guy here, and I don't. I really don't. I think there was something going on with Kevin, Chris, and Brian, and with John. And that's what I really, truly believe led to this heated argument, why they wanted him at the house so bad. I just don't buy it that all these people are going to do what they're doing for Brian Higgins. I just can't buy that, but I could be wrong. And if I'm wrong, I'll admit it. I don't care if I'm wrong. I just want Karen Reed to be free and get back to her life, right? Oh, we're back. Sorry, guys. It happened quick.
Not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that your honor can make the proper determination.
Oh,
that is my genuine goal for my presentation.
Love this guy.
As I go through, and I know I don't have to say this to your honor, you can feel free to interrupt, pressure test me on anything I'm going to say.
I got to write some of this down. Pressure test me.
I believe if I can get through the chronology, my hope is that the facts will speak for themselves. But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th. and I have the transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor.
Great.
And because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be
I
methodical.
love this guy's use
All right,
of the
so
English language,
Are
don't you,
You're
Kara?
addressing this in
Yeah.
chronological order as well, right? So if you can tell me those pages now, I'll likely recess because I do want to see them before you talk about them,
Oh
but
my
I'll hear
gosh.
you going up to that point. So what pages are those?
And you're referring, Your Honor, to the February 18th transcript?
Yes,
Yes,
your
I will
number.
tell you exact
8.
pages that I'm going to refer to. And Your Honor, gets to the, this is
Yes,
tab
yes, Willie B.
8
Right.
of the notebook.
Good
Mhm.
one.
And specific pages that I'm going to reference start on page 53.
Okay.
And those are 9 pages that proceed all the way to,
I'm taking notes so we can talk about this on Friday Night Lives.
really, the substance ends on page 62.
All right, 53
Okay.
to 62.
And I appreciate that Your Honor wants to take a look at them, because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So am I understanding, Your Honor, that you would like me to
You
suspend my
can,
brief or keep going?
no, you can keep
Okay.
going and we'll stop so I can read whatever I think I need to read
Sure.
at certain points, but we should be good to at least start.
Okay,
Thank
Beth,
you.
I'm good with that.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
Okay. All right. Go
Yeah.
right ahead, Mr.
You know why she
Wilson.
said that?
Thank-
She wanted
thank
to
you, Your
scold
Honor.
him for not giving it
So
to in
I
advance.
start with
I know,
tab
I've gotten to
1,
know her well.
which is the March 22nd, or excuse me, go to the bottom, please, the
Thanks,
March
Billy
20,
B.
2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts, but I want to go backwards to start in terms of something that is well known. And that is the federal investigation and the products of that federal investigation produced the ARCA report. And that was in February of 2024. So what preceded this communication was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents in March of 2024. And as Your Honor will recall, the trial 1 started in April of 2024. So it was pretty close to when that trial started. And I
Good.
know Your
Good
Honor
review
knows
of the history.
from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report that the vehicle, and this is, the substance is important, Your Honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Miss Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense. Next step, important also. Any party, the Commonwealth or defense, had access to ARCA. They had the opportunity to contact ARCA. There were restrictions that I'm going to get to on that contact. But either party had the opportunity to contact them. Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know. But I understand the facts to be that the Commonwealth didn't make contact with the ARCA experts. The defense surely did. So that is the background. That is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as Your Honor also knows, the rules of the road with regard to the ARCA expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the ARCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth. So with that, we come to the emails on tab 1. March 20, Mr. Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yannetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important. So we have a communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your Dr. Rentschler's and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was
Was the federal protective order that was referenced by Ms. Giannetti that said it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, I wanted to say, I'm going to answer it directly. What Mr. Yannetti articulated is the rule of the road, not prep, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the ARCA experts, okay? That was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation, but I do not know the answer.
All right, go ahead.
And it's an important question, important answer, I understand. But I'm good. The logistics for your preparation in the trial. Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yannetti is not copied on the email, and my understanding is Mr. Yannetti is not knowledgeable about these communications. So the email reads, "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it." Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly in code at that point. Why would Mr. Wolf be saying, until we receive additional information from their office, the U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So what happens is I call this the pause email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCA's willing, if they're ready, if they're able, etc. And then we have the pause. The next tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between then? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yannetti never mentioned the ARCA experts in his opening?
I did not review the openings. I reviewed only for the non-evidentiary transcripts I reviewed was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yannetti did not even mention the ARCA experts because the defense didn't even know if they would be testifying. The two most powerful witnesses in support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get there.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th.
Right.
And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening. So that pause continued through the opening. That to me is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript. And as I said, I am going to hit head on these areas. I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've been given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy. Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire, and that the ARCA witnesses were going to have to come up from Pennsylvania, and they were going to need to sit for a voir dire. I will get to the significance of that, but that's what started, is the predicate for the discussion I'm now going to focus on. It starts on, this is tab 2, page 2812. Line 5, the court. Now, regarding the 3 experts from ARCA, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we've provided everything that we know. We mentioned to this court at sidebar, these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, these experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court, and it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question—
That's exactly what I said.
Pardon me?
That's exactly what I said.
Yes. And I want to key in on you've never spoken, right, to and putting them on the stand. Now, no one ever said from the defense they never spoke to them, but that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes two people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says, that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background. And I've got definitions of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue. We have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. And I know the immediate response might be there. It might be at this point, wait a minute. You haven't had time to interview, et cetera, et cetera. But what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yannetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yannetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor, and this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for a voir dire that can testify, yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is now fighting with bringing them in for a voir dire. That's, Mr. Yannetti says that is fine. So I said I'm not going to conflate issues, but there's overlap of issues. So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get to how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3. And it's the June 18, 2024 voir dire examination of Dr. Wolf. And before I get to the specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anybody to ask virtually any question they want of the witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right? I don't know who even is opining on what. I went back and looked at that, Your Honor. Pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense's making. We got what was sent in cement, the reports. That's the way they came. We didn't create a report that blended experts as to what they were going to say. That's what got dropped in our lap. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement, unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism because the Commonwealth had the opportunity to interact with the ARCA experts. They had the opportunity to call them as witnesses. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell. That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolf. What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them. But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions. Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages, not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf the questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct talking about nighttime visibility work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility in pedestrians affirmatively in voir dire. So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask. And as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email, but it's important who it's from and who it's to and who's not on it. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on, but they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face. And one of it is you can always tell what goes along with the email. So this is attachment Wolf-Qualls document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor? Mr. Wolf prepared the document, not Mr. Jackson.
No, I was well aware of that.
Okay, so he prepares it. He sends it along to Mr. Jackson. And it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor. The next tab, and of course, it has the D&T of Dr. Wolf, his experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that, to me, would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, inquiry, but again, that's what voir dire provides the opportunity for. So next we have tab 5. June 23rd is Sunday at 2:59 p.m. from Daniel Wolf to Alan Jackson. Subject Wolf Direct, attachments, Wolf Direct. So it's clear, and then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of ARCA, the frozen in concrete report of ARCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the rule 14. And we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things. First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, and I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson. Now I want to get to the timing, because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring, Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it, came to my mind. We know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think, perfectly tailored to the situation to basically say, I don't, as the court, understand These folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of we got the report, and all we had is emails in March, right? That are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up. Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, a great deal of my work is in the field of lighting and visibility. So there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited, discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is again by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Ms. Little? No, that's correct. Mr. Unetti? No, fact. As a matter of fact, you had never heard of this case. That's correct. Page 3670. Line 10. Question. When did your analysis and conclusions, well, let me ask it this way. You finalized the report, you and your team, correct? Answer, correct. Question. And that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer, correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with the March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement, to the best of my knowledge in my review of all these facts and discussions with counsel. So then the next, that's correct. Question. As a matter of fact, I've never asked you specific questions about your testing before today. That's correct. Mr. Wolf sent in questions that he proposed Mr. Jackson ask, but that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in. And Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation, but I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country. He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having, but he's got to go on the stand with his professional reputation, and he's nervous. He's nervous. So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will not.
You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor. And
If you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And I
Okay.
think the only way to fairly.
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolf's situation at the time the direct was sent. So can I say for certain? No. Can even Mr. Jackson say for certain? No. That's the sense, though, that was extant at that particular time.
Okay.
So we then go down to the next question. But I want to come back to that question on 12. As a matter of fact, I've never asked you specific questions you're testing before. That is correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding. Yes. And you were equally available to both sides in terms of them reaching out. Correct. Yes. And I called you ultimately after receiving your report and asked if you join us and testify. Correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had equal opportunity to contact ARCA. That was Dr. Wolf's sense as well. So that is the direct testimony of Dr. Wolf. And I want to just speak to the findings because on page 3676 to 3677, because the findings never changed one iota from the report ARCA issued in February to Dr. Wolf's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings and you're going to deal with the findings that they have. So what were those findings? Bottom of 3676, line 25, did you perform an accident reconstruction? Specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes, I think that's a fair characterization. And reversing that was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle. So it's important to know in terms of, you know, whatever the interactions were and whatever the effect of the interactions were, is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, you know, the fine ARCA being that the vehicle did not come into Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice. I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARCA invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your preparatory statements about these line items that are in it. We don't run from one word or line in this invoice. But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March, and it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial. I'm not speaking with firsthand knowledge on any of this, but I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice. Came out of the blue. It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount. So what happened? And this is, Your Honor, objective. These are recollections, information. The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it? I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay it. Why would the call go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, the date of the invoice is July 12th. And I think I can get you the exact dates here. Mr. Jackson's firm, not Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the substance, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, maybe I'm going to roughly estimate the 24th. And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week, within that July 24th date?
Get you an exact answer?
I would like that.
Sure. I'm going to attempt to get an exact. If I can't, I think I can get a good approximation. Your Honor, I understand a check was sent to ARCA on July 25th.
Thank you.
You're welcome. So there's no doubt the invoice was paid. But the story is not solely about was the invoice paid. The important part of the story, but the facts, is it came out of the blue. And I don't expect anybody to take my characterization 100%, but that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question, and it's very important question. But it's an important fact point as well that call was made. So in terms of the next tab, which I've been alluding to during
Okay, so this is the one I said I needed to take a recess to read
I
that.
was just going to say the same thing.
All right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
All rise.
You are muted.
Okay, well, 15-minute recess, good, because I need another cup of coffee for this. I don't know about all of you who are watching, whether you're watching with me now live or you're watching on replay later today. But yes, I'm going to go make a fresh cup of decaf coffee, though I don't want to get too wired. I think that he's doing an amazing job. So I don't know what you guys think, but I really enjoy watching him present the law. He's just so knowledgeable. Yeah, he's fantastic. So I love putting up the words he uses that, to me are words that we don't hear in every day. Now, there's a lot of legal jargon that we don't hear every day, right? So I haven't spoke about this yet on my Men Are Dumb series that I'm doing once a month, where I'm talking about really crazy dating stories from those that join me live and my own. And I was dating a lawyer once for a time, probably almost a year to come to think of it. And halfway through that, I went back to college as an adult. I was in my 30s. He went back to law school as an adult. So he moved down to Iowa, and I was still in Madison going to UW-Madison. So now we had a long distance relationship, and we're both in school again in our 30s. It was kind of crazy, but we made it work for quite a while until it didn't work. And it didn't work because he was busy having time and fun with all the lady lawyers down there in Iowa. I'll tell you, that's the honest to God truth. And he wouldn't deny that. So, but when we broke up, I was making comments to him about how he seemed cold and he wasn't himself. And he says to me, hence the lack of hugs and kisses. And I have never forgotten that. I have shared that with a lot of people because it was just so ridiculous. Like, what a thing to say to someone that you had been friends with prior to dating, dated for a year. Hence the lack of hugs and kisses. So, yep, there's your lawyer speak for you. So I've been putting up the elucidate, right, is a verb. So to make something unclear, easier to understand. And Willie B, you said that I'm so sorry to learn of your mother's passing, Willie B. Oh, it just stinks. My father died when I was only 19 of cancer. So I've had to live. Luckily, I had wonderful grandfathers. My dad's father, unfortunately, died very shortly after him. He was hit by a car, very tragically. And then, but my grandpa on my mother's side, my grandpa Ray, he lived to be 87 years old. And his wife, my grandma, she lived to be 90. So I had like two sets of parents. I was so lucky. They really weren't like grandparents. They were like parents to me. They were like grandparents to my two sons. And he was awesome. He loved using words that not everybody used in the common practice of day-to-day life. Right. So, and I know I miss him terribly. And my mother too, she super smart, wicked smart, and she's 83 and she loves to use the big words. So I'm sorry for your loss, Willie B. Truly I am. I know that with my mother turning 83 this summer, I have to face this sooner than later, and I'm not willing to even consider it right now. So, all right, Julie says, same, going for coffee or tea or whatever it is you love. I reserve Diet Cokes for Friday Night Lives because it's not good for my stomach. So, but I love my Diet Coke, so I will have it on Friday Night Live. So, okay, so Julie just said, OMG, the local news just put up a page today. February 25th is National Clam Chowder Day. Okay, great. Who doesn't love a good cup of clam chowder, especially all of you in Boston and Massachusetts, right? But we like our clam chowder down here in Florida too. And it's served in Wisconsin on Friday night fish fries. So yeah. All right, kids, I'm running to get a fresh cup of, maybe I'll go tea, coffee, not sure. I'll be back very soon.
the Burlington Mall this Friday, February 28th, from 5 to 7 for our live bundle coat event. Our own Latoya Edwards and Raul Martinez will be there, along with Mix 104.1's Carson and Kennedy. They'll be right outside Lululemon, so bring a new or gently used coat to help keep New Englanders warm. It's all in partnership with the nonprofit Cradles to Crayons, and we will see you there.
Now to the transcript. And as I go through, I start on page 53.
Okay.
Line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCA as a witness was made 5 times. I counted them, and I'll go through each one and number them. Or deprive the defense of an ARCA expert in this case. Very important, because my perspective, what was put in the firing line on February 18th was the ARCA experts, albeit indirectly. So now we go to page 54, and this is going to be, in some points, a line by line, because the words matter. Line 5, and this is again is Attorney Brennan.
Mm-hmm.
Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? Don't know about the ARCA experts? February 12th report? a voir dire, knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that that expert is biased. But this expert was not engendered by the defense. It was engendered by the U.S. Attorney's Office in their federal investigation. Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false. So this is a buildup. It's all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was February 12th that it was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, et cetera, et cetera. So I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay.
So let's go through each word because it gets really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping, it's important to understand and get behind those verbs as to what the facts are. So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the ARCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCA. And why do I keep repeating this? Because my conclusion is going to be ARCA should be unscathed. ARCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance And believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before, but his comment here is I've read the transcripts, and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on, and he, on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55. Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with defense counsel. That's what was talked about above. So I called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you my impression from what is stated here is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information. So they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so ARCA could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but a qualifier, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCA, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds? When he really got it from the defense. There's email correspondence between the defense, but not only the defense and the federal government, but the ARCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these ARCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements or payment They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection. There was no promise, rewards, or inducements or payments before all of those documents that the Commonwealth is referring to here. That didn't come until the invoice came in July. And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it. So next, on page 57, line 11, he reads, response, "Hi, Alan. Subsequent to our conversation on Wednesday," this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates. So it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, I'm going to please ask you to turn back to tab 1 of my notebook, because this was a purported quote of the March 22nd email. That's really not close to what the email says. It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the benefit of the doubt, because I can tell you that I've had my statements in court not completely correctly transcribed by a court reporter. And unfortunately, sometimes it's been on some key things. I don't think this is key at all, but I just note it. But it says, Mr. Brennan goes on, "Now it's the opinion that troubles me. It's relationship, and the Commonwealth should have an even playing field." That's number 4 of the time he's not having any trouble with the ARCA experts. Saturday, June 22nd, Daniel Wolf wrote, "Alan, I spent some time this morning putting together a brief outline of my qualifications, blah, blah." And this is just a repeat of what we have already heard. Here now comes the important points. Page 58, line 2. Now, this isn't information provided by the defense in reciprocal discovery. Oh my. This isn't information. She's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests, jury requests, and an insistence, the best I can, to get as much information as I can. It's incorrect statement number 2, and it's an important one. Down below, unfortunately, it gets even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. My Mine. That's not a fact, but if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll stop back up at 2.
Okay.
Right. Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea? And I'm not rushing you. Do you have an idea? Because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes because I have to get to the law, the 3.3A. I have to.
I'm not rushing you. I just wanted a time frame.
Best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2 o'clock. You are muted.
Goodbye.
Pause for now. We will bring you back down to Dedham when they resume. And later tonight, be sure to tune into our sister station, NBC 10.
Hey, everybody. The court is on a lunch break from 1 to 2 p.m. Eastern. So I will put up a new link for a new stream for the afternoon session. Thanks to everybody who joined me live this morning, and thanks to everybody on the replay. And I'll put up the afternoon session shortly. You can find that at Social Change Warriors on YouTube, and I'll also put it up on Twitter, X, and on Facebook. Thanks, everyone. See you in about an hour. So far, so good, right? Free Karen Reed, just us, justice for John O'Keefe.
They try to silence the truth we shout, but we're still here, we're still calling out. Corruption hides behind a badge of name. We light the fire, expose the shame. We're justice seekers, we'll fight the fight for every voice lost in the night. My life mattered is the cry we sing for the ones they tried to bury within. It's just us, we're a movement wide. Together we rise, won't run nor hide. The stories echo, the pain runs deep. For stolen lives we can't just weep. Elected power, but their hearts are cold. We'll bring the truth, let it be told. We're justice seekers, we'll fight the fight for every voice lost in the night. My life mattered is the cry we sing for the ones they try just us. We're movement wide. Together we rise, won't run nor hide. We're justice seekers. We'll fight the fight. The heroes undo the harm. Calling out corruption, we'll stand tall. For justice and truth, we'll risk it all. My life